Good morning, Mr. Kennedy. Good morning, everybody.
Good morning, Chair. Are we ready to proceed
Yes.
with the...
Good morning, Mr. Mantsha. Thank you.
May I indicate...
You are ready to proceed.
Thank you, my Lord. May I indicate that Mr. Mantsha is today assisted by his attorney, Mr. Denga.
Yes, okay. You can place yourself on record from where you are if your mic is working. If it's not working, they will sanitize the podium.
As with the hearing, I'm Mr. Denga, appearing on behalf of Dan Mantsha.
Thank you very much.
Yes,
Thank you.
Thank you, Chair. Good morning, Mr. Mantsha. Mr. Mantsha, I'd like to pick up on the point where we...
Hang on, Mr. Mantsha, are you going to prefer to have your mask on today? Okay, all right. Okay, thank you. Yes, Mr. Kennedy.
Thank you, Chair. Mr. Mantsha, we were dealing last time with the situation concerning the termination of employment of the then Group CEO, Mr. Saluji, the Group CFO, Chief Financial Officer, Mr. Mshlonklo, and the company secretary, Ms. Africa. And you recall we started dealing with the process that was followed in that regard. And we were looking specifically at the steps that were taken in relation to the disciplinary inquiry that they had been told they would be facing. And we were exploring why it took so long, and ultimately it never took place at all, because the termination of employment was then done by settlement. Now, Mr. Mantsha, I'd like you please just to confirm you have before you a bundle. Hopefully what you have in front of you is Exhibit W4B. Do you have that?
I do, Chairperson.
Thank you. And we looked at part of the annexes to Mr. Saluji's statement last time. I'd like to take you, please, to bundle this bundle, and it's got different page numbering system than some of the other bundles. So it's just bear in mind in this file we have to look at the numbers on the top right-hand corner. And I'd like you, please, to turn to page RS 405.
Page?
RS 405. When I'm dealing with this bundle, I'm going to omit reference to it, RS, unless we run into difficulties. Right, do you have that? That's a letter from Zarina Walele, attorney.
I do, Chairperson.
And we looked at part of that letter on the last occasion. That's a letter from Ms. Walele, who at the time was acting as the attorney for Mr. Saluji, Mr. Mshlonklo, and Ms. Africa, correct?
Correct, Chairperson.
And it's dated the 18th of February 2016. Now, by this stage, Mr. Saluji, Mr. Mshlonklo, and Ms. Africa had been on suspension since September. Is that correct?
Correct, Chairperson.
And they had received a charge sheet, I think it was in December of 2016, and we dealt last time with the process in which that disciplinary inquiry was meant to proceed in January. Instead, it didn't proceed. Instead, a mediation process was attempted, and there was various correspondence between the attorneys. Cliff Decker Hofmeyer, to whom this letter is addressed, were acting at the time for Denel. Is that right?
Correct.
Yes. Now, we already dealt, I believe, on the last occasion with the first part of the letter on page 405, where Ms. Walele referred to your appearing as chairperson of Denel before a select committee of Parliament, where you had made statements that, and she quotes there, these officials were in breach of the law and they failed to observe the legal requirements of the PFMA. You recall we dealt with that in your evidence last time.
I recall, Chairperson.
And you recall saying, yes, you said something along those lines in Parliament.
Chairperson, if I were to repeat myself again, I said I'm not going to take this statement because it is allegedly reported by the paper. And I told the chairperson that parliamentary presentations are in a documentary form. So if that statement which I made from Parliament was to be quoted, then I would either agree or disagree. But I cannot comment on statements which are allegedly coming from the paper. And I then said to your chairperson, I would be very conscious, as in terms of my own training, not to put the word alleged. Yeah, so that was my answer.
Right, thank you.
Can I take that to mean that you are saying you don't want to commit yourself as to whether you were correctly reported to say you had said this, but you say there would be some document somewhere which reflects what you said.
Indeed, Chairperson.
That's what you are saying. Okay.
Thank you, Chairperson.
Now, what Ms. Walele says on the following page is that this is unfortunate because it indicates a view on your part and on the part of Denel that her clients, the three individuals, have already been found guilty before even having a hearing. What do you say to that? There was no response that we are aware of from Denel's correspondence to that letter to say, no, in fact, Mr. Mantsha didn't say that in Parliament, or to say, no, there's no decision already taken by Denel as to your guilt.
Chairperson, with respect, this letter is addressed to the then attorney of Denel at the time, whom I have no doubt was competent to deal with the matter. And I had no doubt that where necessary, he responded to correspondences. Okay. So,
just come closer to the mic so I can hear you.
Thank you, Chairperson. All I'm saying is the letter was addressed to the then attorney of Denel, so not either to my board or to myself. So whether there was a reply or no reply is not a matter within my knowledge. And whether there's a complaint that these three employees were found guilty before the disciplinary hearing took place, listen, she was entitled to represent these people and she was entitled to say whatever she said. But all I can say to you is this was never brought to my board. It was not addressed to my board. So I'm not going to comment.
What she then says in her letter, and you may have the same answer to this, that's up to you whether you want to comment on this, but I believe fairness requires that I put it to you, that what she then records in paragraphs 4, 5, and 6 is a concern that her clients hadn't yet been heard and that they were requiring, she said, we insist that the disciplinary process that your client claimed in the same forum, that was Parliament, is underway, is convened, or at the very least a date is agreed upon for it so that the matter can be finalized. Were you aware that the three officials who were still on suspension, on full pay, through their attorney, were repeatedly, through their attorney in the correspondence, saying, we haven't been heard, we want to be heard, please would you get on and convene the inquiry? Were you aware of that?
Well, Chairperson, again, I think we must distinguish the role of the board. and the role of the executives, including the legal department of the company. The legal department of the company with the executive, they were in communication with the attorneys who were representing Denel at the time. And I don't think the attorneys of Denel at the time were not responding to the correspondences. But what you don't have, Chairperson, you don't have a correspondence from Denel attorneys at the time addressed in reply to this, which of course have given the reasons. But be that as it may, Chairperson, of course, is I'm not trying to suggest anything, but it's one thing to present correspondences from one party, and you don't present correspondences from the other party. And the correspondences that we're dealing with here is correspondence to the attorneys of the company. I'm sure the company would probably maybe have the records, or maybe the attorney in questions have the record, but reputable as they are, I don't think they were not responding to correspondences. Whatever answers they've given, I can't say because I don't have their correspondences.
Yeah, but the question is, irrespective of whether Denel's attorneys did or did not respond to the executive's attorneys, the question is whether you were aware on the basis of whatever source, which could well be the legal department of Denel telling you as chairperson of the board, or the attorneys, if they had direct communication with you as chairperson of the board, Denel's attorneys, whether you were aware that the executives, the suspended executives' position was repeatedly conveyed as being that they wanted the disciplinary hearing to take place.
Chairperson, what I knew at the time was the matter was not concluded. The attempt for mediation failed, and these disciplinary proceedings were still pending. I was not privy to the to and fro communication between the respective lawyers of the parties concerned. Yeah.
Is that answer to say you were not aware that the suspended executives repeatedly said through their attorneys, we want the disciplinary hearing to take place, taking that position and conveying that position over a number of months?
If I can try to recall, of course, there were communication from probably the legal team to the executive to the board about these processes. But what I cannot tell you now is what was said at the time. But what I can tell you now is that I do not remember being told that these correspondences where there is insistence, please do this, please do this. Yes, Chairman.
Maybe this is the right time for me to say this. I would have expected that in the light of the seniority of the executives who were suspended, that the board would be quite involved in terms of the process for the disciplinary process and the preparations for the disciplinary hearing and the suspension. That's what I would expect, simply because of the seniority of the people involved, including the executives. It would have been different if one was talking about lower management and so on. But the fate of the chief executive of any organization would be in the hands of the board, I would imagine. And therefore, I would expect that even the internal legal department, if they were handling that, they would be reporting to the board and taking instructions in quotes as attorneys would do from the client, because they shouldn't do anything that is contrary to what the board may be wanting to be done. And I would be expecting that they act as advisors to the board, but they would not be the decision makers. The decision makers would be the board. They would just advise. Would this approach be legally defensible? Would that approach be tenable in law? But in the end, the decision makers would be the board. That is what I would have expected. But from what you said last time, and maybe that's what you still say today, that's not how it happened in this case. The legal department did not, so to speak, take instructions from the board or from you in regard to the handling of the disciplinary process.
Okay, Chairperson, maybe let me put this in proper context. The board has taken a decision which it had to be implemented. In terms of course, governance, the decisions of the board, they are implemented by various functionaries. And this specific decision, the functionaries involved in the HR department, is the legal department, and of course, in terms of the protocol, they report to whoever is the chief executive at the time. So the decision was taken. The implementation is done by those functionaries. Those functionaries will report as they execute or implement the decision. But again, what you don't have is any of the reports from those functionaries to the board that says this is what happened, this is what not happened. So to then ask me almost 4 years down the line, 5 years down the line, of course I wouldn't have, that information in terms of what was reported. And maybe to correct the impression as you were trying to relate to me now, the board did not just took a decision and walked away. The board duly expected the management to process in terms of the governance of the company. And there were interactions between the board and the people who were involved. There were displeasure, as I indicated previously, that the board expressed about this process. But of course, you do not have, that information. That information is not within my control, it's within the company. That would show. Because, again, the actions of the board are through the minutes. And the minutes would say exactly there was a report by group legal, there was a report by this one, HR, and these are the status issues. So those reports would be there. And again, I repeat what I kept on emphasizing throughout, from the beginning of my evidence. The board was overwhelmed by the bigger issue. I understand the position of a chief executive officer, but at this point in time, the board was overwhelmed by the situation where the country could find itself in a serious crisis because there would have been a default by the state-owned company, and that would have meant that other lenders to other companies, state-owned companies, might recall their bond. So that was an issue of national importance, which the board was preoccupied. But I'm not saying the board was not serious about this matter. Yes, there were reports which were given, and I'm sure the records of the company will reveal in every either meeting of audit and risk, what were the reports given, as the status of this suspension, what the lawyers were saying. I'm sure those reports are there.
Mr. Kennedy.
Thank you, Chair. Let me say immediately, Mr. Mantsha, I do understand it's some years afterwards, and I can't reasonably expect you to recall every last detail, and that's why I think most of my questions in the last few minutes have started with, do you recall whether there was a response to this? Do you recall why there was a delay, etc.? And that's really what we're after. And if you can't remember, you must say, I can't remember. What I can take, and sorry, just the other point that I just wanted to draw your attention in response to one of the comments you made. You said all that's being presented to you are the letters from the executives, attorneys, and there are no letters that we have produced from the attorneys acting for Denel at the time, Cliff Decker. In fact, this bundle includes various letters from Cliff Decker, from Mr. Adil Patel, some of which are relevant to what we're dealing with. Some were in fact raised on the last occasion, I believe, but we're going to deal with a few of the crucial letters in that regard from Cliff Decker. So there's no selectivity, certainly not on the part of the Commission and its investigators and legal teams. We have repeatedly asked Denel for all the documentation, and we have produced to the Commission in the form of the bundles that have been admitted by the chairperson all the relevant documents that seem to be material. But may I now take you, Mr. Mantsha, to a letter which in fact came from the board and in fact came from yourself. If I can ask you in the same bundle to look at page 412, please. That's a letter from Denel. It's on the Denel Group letterhead. Do you have it?
I don't, Chairperson.
And on the top right-hand side, just under the heading Denel Group, it's dated the 17th of March 2016. You see that?
I do.
And we see your name and what appears to be your signature on page 413. Is that your signature?
Correct, Chairperson.
Right, thank you. Do you recall that you sent this letter? If I can just remind you, we're going to look at the detail in a moment, but this letter effectively was saying the board has decided not to renew Mr. Saluji's fixed-term contract when it expired. Do you remember that decision was taken by your board?
I do remember.
Right. And this is the letter in which you recorded this, and just if we go back to your signature and name on page 413, we see that it's typed CC, Zarina Walele attorney. So she was CC, she was copied in on this letter.
Correct.
Which was addressed to Mr. Saluji personally on page 412, but quite correctly, you or the people who were preparing this letter and advising you quite correctly, as a matter of courtesy, addressed a copy also to Ms. Walele. Is that right?
Correct.
Right, thank you. Now let's just look at a couple of the paragraphs of your letter. It's headed Termination of Employment Relationship, Group Chief Executive Officer position at Denel. Now if we can just remind ourselves where we are in the sequence. This is the 17th of March 2016. Mr. Saluji had, as we've heard much evidence on, been suspended about 6 months before that in September, correct? September
Correct.
2015. And they had then received a charge sheet saying they were going to be disciplined. They were suspended pending that disciplinary process, and we've seen letters where there is a complaint that there's a delay in the disciplinary. Why aren't you convening it, and why aren't you sending us documents? We've dealt with all of that. Now, your letter doesn't say we're going to now hold the disciplinary inquiry. It deals with another matter.
Correct.
And that is the termination of the employment relationship, not through the disciplinary process, correct?
Correct.
You could have proceeded with the disciplinary process, at least in theory, held it if you had substance, if Denel had substance to the charges and persuaded the independent chairperson that Mr. Saluji was guilty, he might have been dismissed at the end of that process. But here you were saying that you're terminating the relationship on a different basis, on a contractual basis. That's
Correct.
Right? Yes. So you say in paragraph 1, the above matter refers to the board is of the view, this is Mr. Saluji, that your, Mr. Saluji's contract of employment was not validly extended as per the PFMA. Nevertheless, your alleged current fixed-term contract of employment terminates on 31 January 2017, notwithstanding your current suspension as the Group Chief Executive Officer, which was effective from the 23rd of September 2015. Now, this contains quite a number of elements to it, but just to unpack it, essentially what you're saying is there is doubt as to whether, in fact, Mr. Saluji's current contract had been validly extended, but despite that reservation, you had decided as a board that if there was a contract at all still in existence, it was going to expire on the 31st of January 2017, and it would not be extended. Is that right?
Correct.
Yes. And then you say this, the alleged acts of misconduct are viewed in a serious light, and as a result, the trust relationship between the board and yourself has irretrievably broken down. Now, as I understand it in context, you're referring there, but correct me if I'm wrong, the alleged acts of misconduct are the alleged acts of misconduct according to the charge sheet, which was already issued to them for a disciplinary inquiry that was pending. Is that right? You're not referring to other alleged acts. Correct. Now, I just want to ask you, and let me explain the relevance up front so that we know where we're going. I'm raising the next series of questions really to deal with the evidence that the Commission has heard from Mr. Saluji, and the Commission's chairperson will obviously, with respect, have to weigh up all the evidence from Mr. Saluji and from yourself and anybody else who may have testified in this regard. Mr. Saluji's version is one that paints a very negative picture about the board and you in particular in relation to why he was suspended and why and how his employment was terminated. And you'll recall, because as you've confirmed previously, you've seen at least parts of the evidence that Mr. Saluji provided to the Commission previously. You will recall that Mr. Saluji's evidence, and I hope I do justice by way of summary, is that there was a sinister purpose to the suspension, the disciplinary charges, the failure to hold a disciplinary inquiry, and ultimately to terminate the relationship inter alia in terms of this letter. And a text that he has really proposed, as it were, a notion that he has proposed to the chairperson is that what you were really doing, you, Mr. Mantsha, as chairperson, and those who acted with you, was really to get him out of the organization on a pretext, that the charges against him were a pretext, charges about misleading the board at the first board meeting, etc., was all a pretext, and that in fact you were trying to contrive a false basis to get rid of him, and the real purpose was because he was perceived as being somebody who would not facilitate the awarding of contracts to the Gupta business conglomerate. You recall that that was essentially, I hope I do justice to his version, but I'm trying to give as brief as I can. So that is his theory that he has put before, or view or opinion that he's put before the chairperson. Now, you strenuously disagree with that. You've already said that on the previous occasion. Correct?
Yeah, Chairperson, should I just say something? Look, I'm going to repeat myself. Mr. Saluji had no problem with Mr. Issa because Mr. Saluji negotiated that Mr. Issa buys VR lease. This is the information that I told you before that I had received. Mr. Saluji was working with Mr. Issa, and I said to the Commission, I'm not saying anything beyond that. The reports which are tabled before this Commission, the BDO report, they did inform this Commission that the investigation was that the entry of VR lays and to Denel was not properly.
Was not?
Was not properly.
Yes.
And therefore, they're taking actions to those executives who were involved, who were still there. And it is before this commission that the evidence from the so-called people implicated in signing the first, either you call it memorandum, whatever the case is, Vessel told this commission that he was told by Mr. Saluji that we need to work with VR. He gave his reasons, what he was told. Mr.
That
Beg,
we need to work with?
they need to work with VR laser. Yes. Mr. Berger, the same. Mr. Nsepe, the same. So, I don't think it's going to help us that I must keep on repeating my answers because questions are asked
No,
differently.
no, Mr. Mantsha.
Yeah.
No. Mr. Kennedy's question is not the one you're addressing. His question is, what do you say to Mr. Saluji's evidence that you or the board of Denel suspended him not because of any proper grounds, but because of some other agenda? Because you suspended him on the basis of allegations of misconduct in September. He was ready for a long time for a disciplinary inquiry. You made approaches to him to try and resolve the matter by paying him money, by paying them money. They rejected that. They said, we want a disciplinary inquiry because we want to clear our names. When there was supposed to be an inquiry, you, Denel, proposed mediation. And he said, at the mediation, they took the position that they want a disciplinary inquiry to clear their names. And that's why the mediation failed, because that's what the stance they took. And if I recall correctly, they asked for some documents as well. Now, you will remember from last time that the evidence revealed that sometime in December, you had Denel made an offer. I don't know whether it was for 3 months payment, just before the the charge sheet was sent, if I'm not mistaken. And then now we have a letter, a number of months, 3 months after that, in March from, in March from you, the letter that we are looking at, 17 March, where despite the fact that you said right from the beginning when you suspended them, Denel had strong evidence. In March 2016, you still don't want to use that strong evidence and have a disciplinary hearing. And if he is as guilty as you say you thought he was in terms of the evidence, get him dismissed without him being paid for so many months, but you are offering to let him be paid for maybe something like 8, 9 months. Somebody that you believe is guilty of serious misconduct. So I think it would be in your interest to address that issue properly, because I'm very interested to hear your side of the story on that, because to me, on the face of it, there seems to be a problem when the employer says, I have strong evidence showing misconduct, serious misconduct by this employee. So I suspend him in order to have a disciplinary inquiry. And 6 months later, despite the fact that there is strong evidence, there is no inquiry. And on the evidence that I've been told, the employee or the employees keep on saying, bring it on. Let's have the hearing. They don't seem to ask for any settlement, but it's the employer that keeps on approaching them for a settlement. There is a mediation. They say, according to their evidence, we want a hearing. In March 7, 2016, you now say, yes, your Your conduct, the allegations against you are very serious, but we want to pay you for about 10 months. When you could say, come next week for a hearing, we've got the evidence, we believe that you will be found guilty, and then you don't have to pay him for 10 months. So I just want to say it's important that you address that, because on the face of it, it calls for an explanation to say, if you have got evidence and you believe it's strong evidence, why have you not held an inquiry for so long? So I'm mentioning this to you because it's important that you know some of the things that are causing me concern so that you can address them head on. That's the purpose.
Well, Chairperson, thank you very much. All I'm trying to do before you is to actually give you the context, because the point the evidence is driving to is that Mr. Saluji would be an obstacle in terms of the Denel Asia. I'm saying this because when I gave you that background, it's simply because he was not an obstacle to VR Laser because he brought VR Laser to Denel. So one cannot say that the charges had something to do with the VR Laser because he brought it. So to then suggest that the charges have to do with Denel Asia, I'm then trying to give you that background. That is nonsense.
No, if you put it like that, I understand that background. Yes. So you can carry on. Yeah.
So all I'm trying to say,
you'll have to deal with that. So, but that background is good. Yeah. But ultimately, I must listen to everything you have to say.
Yes. So all what I'm saying is, to say these charges has anything to do with the decision which was ended up taking Mr. Issa as a partner to Denel Asia. You know, this is what I want to address, to say he had a long-standing relationship with Mr. Issa. He made a lot of efforts to get Mr. Issa to Denel. I recall when we were in London, he pleaded with me when he was in confidence telling me some of the efforts he has made to assist Mr. Issa. But he has always said to me, well, this is what I've done. But in terms of the understanding of us as a board and my understanding, the defense industry in this country is an industry where there are no black players. And part of the mandate from the shareholder, who is government, to Denel is that please transform the industry. We want to see black suppliers on the main business of Denel, not to supply toilet papers and whatever. So VR Laser, according to what has been presented and according to what Mr. Saluji said, it was that black empowerment partner which plays in the space of Denel main business. And it was the only black company as it was presented to us. So in short, all I'm trying to drive to is that there was no any other motive to put these charges against Mr. Saluji and his two core employees. The only motive was the misconduct committed. I recall, I think, my last dinner with him in London. After the dinner, he came to me, he came to my room, and he really pleaded with me that he should not be fired. And that was the very same day when there was a call from the Audit and Risk Committee to say, we are not given access to the committee rooms to have our meeting to discuss the investigation about that LSS transaction. So he pleaded with me that, Chair, please protect me, I shouldn't be fired. And with respect, I was very troubled to see him crying and to see him pleading, because at that time, he realized that the relationship between himself and the board, as a result of the LSA transaction, was broken. And the only thing he could do was to plead that I try to find a middle ground between him and the board. And something that, as I said to you when I started this evidence, I had a very good relationship with him. I think we liked one another. So it troubled me. I didn't sleep that night. So when I got back home, I tried to see if there's any other way we can avoid suspensions and conflict. But the evidence was such that it was difficult because Mr. Saluji and Mr. Mhlonhlo, they went to conclude a 6 months or 5 months bridging finance contract with Nedbank, while the Minister of Finance and the Minister of Public Enterprise had approved a facility for 5 years. And what complicated the matter further was that we did not have the money. We did not have the 450 to pay. So it was impossible to then try to stay off the imminent disciplinary proceedings against him. So the only reason why he was suspended, it was simply because of the misconduct in regard to that transaction. He did not comply with the terms of the approval from the Minister of Finance and from the Minister of Public Enterprise. No one between those two offices knew that Denel had to pay 450 within 6 months. When the matter was reported to the executive authority, the executive authority then implored to the board, please find the solution, because if you don't, then it's going to be catastrophic, because other bondholders will pull and will demand their money, and there will be a cross default. So that was a clear instruction to say, resolve this matter. And I can tell you at that point, most members of the Audit and Risk Committee and some members of the board, they wanted to resign because they felt that they were being thrown, so to speak, under the bus. That the appointments to the board, it's actually an appointment to the sinking ship. So I had to try to get board members there, to get board members to work very hard with the executive, to try to convince Nedbank, which was very angry. As I indicated before, immediately they realized that apart from the fact that they were the transactional advisor to Denel when Denel was acquiring this asset, Denel gave Absa Bank 400 million in cash as a security, and they were given nothing. So at that point, they didn't want to hear anything because they felt they were duped. And at that point, the Minister of Public Enterprise clearly set the condition, please don't conflict the two banks because you're going to ask this money from the two banks. So it was a difficult situation for me as a leader of the organization to try to see how I can get a middle ground between Mr. Saluji and the board, and also to get the board members stay and not to resign, and get the board to try to get some resolution with Nedbank. So it was quite a very difficult challenge.
But what you have said up to now, Mr. Mantsha, might explain certain things, certainly subject to what Mr. Saluji's evidence is on this regard, and maybe other people, in regard to his working with Mr. Essa, as you say, that might be one thing. But nothing you have said so far explains why the board, when it had strong evidence against Mr. Saluji and the other executives, in September 2015, still had not put together a hearing by March 2016. So that I hear what you say, but that's the part that I'm also interested in. I'm not saying that what you have said is irrelevant. Certainly the part that deals with Mr. Saluji's working with ESA is quite important. And the other part that you said also might explain certain things. But I just want to make sure, don't forget that I'm interested on this aspect as well.
Chairperson, I'm actually happy in the sense that I'm talking to someone who, in a sense, very experienced and authority on the labor-related matters. In the name
I'm rusted on it.
In the name of the chairperson.
I'm rusted on it.
So Chairperson, there are of course two issues here that the chairperson has delivered several judgments about, in terms of the substantive issues, and procedural issues. I do understand the chairperson's concern, and to sum up the chairperson's concern is, look, you say you've got a strong case, but you don't proceed to finalize these things. And I think at the starting point, I then said, look, we were very overwhelmed. We were busy with other matters of default. We were not happy with the executive, the departments concerned who were handling this matter. But the fact that the procedural issues and substantive issues, the substantive issues, as I'm saying, Chairperson, is that there was a case, the evidence, the objective evidence before this commission, not from me, and not from Mr. Saluji, sorry, Chairperson, and not from Mr. Saluji, but objective evidence from people who had nothing to do with this, who just investigated the matter. The objective evidence before the commission is that, look, where we are at the moment, we are trying even to work the interest rate that we have paid for 6 months vis-a-vis the 5 years thing. So the objective evidence before the commission is that there was indeed a serious misconduct by this employee. So the issue that the chairperson is raising with me relating to say, you said there was a serious breach, but the disciplinary hearing is not final.
You don't act like somebody who believes there was a strong case.
Yes, you don't act like somebody who believes that. But chairperson is well aware that that does not mean that the breaches are not serious because there was a delay in prosecuting the delays. I think we can cite a lot of case law where there's been delay.
I accept that you can have a situation where you have a strong case that an employee is guilty of misconduct, but you might not follow procedural steps that you are supposed to follow. I accept that. And I accept that just because you don't or you didn't follow proper procedure doesn't necessarily mean that on substance you don't have a strong case. But what I'm saying to you, as you have also indicated, is that I'm saying what one expects from an employer who believes he has a strong case is to act pretty fast. You see, particularly when you are dealing with high executives who are being paid a lot of money while sitting at home, you know. You don't want to be paying a lot of money over many months when you do have the evidence. You don't have to be investigating. I mean, it's different if you must still investigate. When you do have the evidence, one expects that you would act expeditiously. When you don't act expeditiously, one starts looking for an explanation. Why? Because
Exactly.
if there is no explanation, it may well be that one starts to say, did you really have a strong case? You see, so you will see that I'm not saying one will start saying you don't have a case, but one will start questioning, because you are not acting like somebody who believed they had a strong case. So
I think I fully agree with Chairperson on that. But Chairperson, as I indicated earlier, I'm sure the board minutes would indicate the nature of reports given to the board about this matter and how the board acted in those minutes. I think you would see that I think the person who was acting as the company secretary and also a group leader also had to leave. And in the process, because of the pressure from the board, there were some medical conditions because the board was not happy. And the other thing which, of course, triggered apart from that, the fact the process was dragging from our point of view, but there was leaking of letters. The letter that we dealt with last week, the letter which was addressed to the acting secretary,
company secretary,
and the legal whatever, that letter was leaked to the suspended employees. That's how they got it, because the letter was addressed to her. So, and when an incident like that happened, so there was a serious rupture within the organization between her and the executive and other people who were involved and the board. How could a communication between you end up with the suspended employees? So the impression that we formed at the time was that, of course, she was working with the suspended employees. We felt at the time that she was deliberately dragging the process because she probably had alliance or allegiance to the suspended employees. So that was our impression out of all the dragging and the matter not running speedily as we thought. So eventually, we removed her from being company secretary. We got somebody to act in that position. And later, I think we got somebody to act as a group leader. But yes, there was dragging from within. And as far as I can remember, we did act. Yes.
well, I don't think from that I got an explanation as to why, with this strong evidence, the board didn't act expeditiously, other than that you have said that, well, the board was under pressure because of other challenges and what you have just said about the company secretary. I don't want to take it further, but I'm just saying that's the impression I have.
Well, it matters to me, Chairperson, the
Sorry?
impression you have. Because what I'm trying to say to you, in terms of the governance, the board cannot process this. These things are processed by relevant sections of the company. And I'm saying to you, yes, correctly, there was dragging, but that dragging was not by the board. That dragging was by the officials, as I mentioned, the acting group secretary, company secretary, and the acting head of legal, and steps were taken against that person. The person was removed. And I say to you, if you were having the minutes of
the board meetings.
Of the board meetings, because remember, throughout that process, the suspension in many board meetings, it was a standing issue for reporting. What is happening? How far are you? So the matter was being reported. But, for me to actually make detailed explanation, to say, no, this month, this is what happened, that month, this is what happened, the person who was full-time dealing with that matter would be able to explain. How did you do this? Why this was not done in time? But the decision we took, it had to be implemented by those people. So I don't think I can,
take it
say
further.
more than that.
Yeah. No, that's fine. I just want to say this because you have mentioned the issue of minutes of board meetings. Prior to Mr. Kennedy coming into this work stream, for quite some time, I had spoken to the team that was looking at the Denel work stream and said they must obtain a lot of documents and minutes of board meetings. And they had given me reports that they were not finding cooperation. I think I was told this would have been in maybe early 2020 or even 2019 at some stage, that the company secretary was somebody from outside Denel. I don't know whether it was an accounting firm or legal firm, and that I think I was told it was a she. She was not cooperating. At some stage, I even said they must approach the chairperson of the board to try and get assistance. But for quite some time, there were serious difficulties. Those are the reports that were given to me in getting various documents, particularly resolutions and minutes of the board. So to the extent that there might not be certain documents here, it may be that partly that was the problem, but it may well be that the problem was solved at some stage. But I thought I would just mention that for what it's worth. Mr. Kennedy might know better.
May I say something on that, Chairperson? I'm here primarily to explain the actions of the board that I led. And the actions of the board that I led are captured in various board meetings. And since I'm called to do that here, it would be more than fair that I am assisted by those minutes, because, Chair, you would recall, you want...
No, that's fair enough.
The previous board minutes, some of it, you forgot.
No, that's a fair point. That's a fair point.
Yeah, so to a point where I might not assist you, because I might not have certain records.
You might not recall.
I think accept my good faith in that. I would have loved to explain everything as per the actions of the board, as captured by the board minutes. Thank you, Chair.
Yeah. Well, of course, the question which I would like to pose to you in that regard is whether, from your side, you made any approach to Denel to say, look, I'm required to give evidence. I'm a former chairperson of the board. I need documents from Denel that would assist me. And if you did, what was the response?
Well, Chairperson, there's so much hostility. There's so much hostility there, and there is, with respect, condemning and sentencing people without giving them a hearing. So there's so much hostility that you cannot even break the air. So, you know, those things, you know, I would love it in another ideal world. That would be ideal.
Mr. Kennedy, do you want to say something about the board
Yes.
meeting minutes or something?
We have it at various stages since I became involved at a fairly late stage in the Denel stream. We have been engaged in attempts to get further minutes, and some minutes have in fact been produced for us and are included in a bundle that is being made available. But we don't believe that there's anything there that seems to actually shed any light. Otherwise, we would have relied on it here.
Okay.
So I'm deliberately trying to limit my questions to things that are fair to put to Mr. Mantsha, and particularly where we have a letter from him. He can either explain it, or he can say, if he wishes, I can't remember, I can't give an explanation because I can't remember why I said that. But at least we can ask him that. And,
well, whatever minutes are there, if they relate to particularly the period September to the departure of the executives, I think they should be shared with him if they haven't been shared.
Indeed.
Let him satisfy himself about what we have. And if he takes a different view, he might say, no, this one jogs my memory on something that's relevant. Then he can take it from there.
Yes. Thank you, Chair. We'll do so. May I then proceed to return to this letter, Chair, in asking just a few more questions on it from Mr. Mantsha?
Yes.
The Chair asked you earlier that, or he put it to you that if you decided not to renew his contract, he would not be employed after his contract expired. That was in January 2017, correct?
Correct, Chairperson.
And so that was the 10 months that the Chair referred to, 9 or 10 months. In fact, 10 months from March to January. But he would be entitled to be paid out for the rest of his contract. So that would be 10 months he would still receive, correct?
Correct.
And that would, of course, be in addition to the 7 months that he'd already been sitting at home on suspension since September the previous year.
Correct.
Now, I just want to draw your attention to paragraph 4, and I just want you to see if you're in a position, based on your memory, to explain what I'm going to ask you to explain. You say in paragraph 4, the alleged acts of misconduct, which you've already indicated related to what they were suspended for, are viewed in a serious light, and as a result, the trust relationship between the board and yourself has irretrievably broken down. The question of whether they were guilty of misconduct and the question of whether trust relationship had broken down, irretrievably or otherwise, surely was something that could have been dealt with in a disciplinary inquiry. What you were saying here was a view as to the alleged acts of misconduct having broken down, are very serious, and having broken down irretrievably the element of trust. That was said to Mr. Saluji in your letter to him without having afforded him yet an opportunity to be heard. Is that correct?
Correct.
And he says, not what I'm saying, he says, I'm just simply putting to you his version, he says that shows that you in fact had a closed mind. You were determined to get rid of him without a hearing. Any comment on that?
Well, Chairperson, Mr. Saluji knew himself that the allegations against him are so serious. And that's why, as I said, he pleaded with me that I should try to avoid that he gets suspended and expelled. So, as I indicated, what the board or the Audit and Risk Committee was dealing with was an objective evidence before the board that says, please pay in 2 weeks an amount of 450 million, which we didn't have. How did that come about? It came about because Mr. Saluji and his CFO went against the instruction given to them as an approval for the PFMA application. The PFMA application say, yes, you can buy LSSA.
Mr. Mantsha, I'm sorry to interrupt you. I don't mean any disrespect, but this is the third day on which we're hearing evidence, and on the last occasion you complained that the evidence was taking a long time. With respect, we do need to try and keep some sort of focus on this. My question was very limited. It was not, was he guilty of misconduct? My question was not, was he guilty of misconduct that had resulted in an irretrievable breakdown of trust? My question is very focused, and it is simply this. When you reached that conclusion that you expressed in the letter, that was at a stage when he had as yet still not been subjected to a disciplinary
Yes.
or any other hearing. Is that correct?
Yes. But Chairperson, I think it's also important for me to give context to a correspondence. Because if you see the letter that he's referring to, the letter starts with, the board is of the view.
Yes.
So which means there was a report before the board looking at this matter. And the report could be saying, look, depending on what they've reported about this hearing, the hearing is dragging. There's pressure to finalize the funding structure with Nedbank, and there's a pressure that the lenders and the partners out there, they want to deal with people who are permanently in the position. So there was a context to the letter.
But the point is that there may have been there may be reasons apparent from board minutes that aren't before us now, but the point is that it was done without a hearing. That's all I'm asking for.
Yes.
Factually.
But,
Okay.
but at the same token, Chairperson, I think for me to explain shouldn't be seen as I'm delaying the hearing, because I think I'm the only person here who has got the background and the information of decisions taken and some of the things taken. So when I'm of the view that perhaps an explanation is needed, a context is needed to be given, so I shouldn't be penalized for trying to drag the hearing.
No. Obviously, we have got to strike a balance between being fair to you, but also utilizing the time properly. Also for your own sake, because you are paying.
Yes, Chair.
So, but I think what you have considered is, yes, there was, the board reached that conclusion without giving him a hearing. Yeah. The one thing I wanted to put to you, you said Mr. Saluji knew, I think what you said, he knew, in effect, how guilty he was. In effect, how guilty he was. You didn't put it like that, but I'm saying you came across as saying, yeah, but Mr. Saluji knew that he knew what he had done. He knew we had evidence. Did I understand your evidence correctly?
I think Mr. Saluji knew.
Yeah.
That
there was a strong case against him.
That there was a strong case against him, and it was wrong for them to have approved 6 months bridging finance without the permission of the Minister of Finance and Minister of Public. That he knew it was wrong.
Yes, no, that's fine. What do you say to the proposition that between September 2015, when he was suspended, and March, when you wrote this letter, he never acted or conducted himself like somebody who was scared of the disciplinary hearing? On the contrary, he was saying, bring it on, acting like somebody who was confident that he would not be found guilty of anything. And he never made, unlike the board, unlike Denel, he never made any offer to settle the matter.
Well, with respect again, Chairperson, I'm speaking with a very experienced chairperson on things like this. That the bravado that accused persons and all sorts of people do in court, sometimes they fight for 6 years, and go up and down and claiming innocent, but it doesn't mean the bravado that you do should mean that you are not guilty of it.
Mr. Kennedy, maybe we should take the tea break.
Yes, please, Chair.
Yes. Let's take a tea break and resume at 11:45.
Thank you, Chair.
We adjourn. Okay, let's continue.
Thank you, Chair. Mr. Mantsha, so you and your board adopted the position then, as we've seen in the letter, that there was a breakdown of the relationship and therefore his contract, which was due to expire the following January, would not be renewed, and that it was proposed that it had been decided that he should not continue to work the rest of his contract until January, but he would be paid out for that period. Is that right?
That's what the letter says.
Right.
Mr. Kennedy, I've just consulted with my registrar because
I'm sorry, I can't hear you.
I just consulted with my registrar
Yeah.
because I seemed not to remember the oath being administered to Mr. Mantsha this morning. And she confirms that no, it was not administered.
I'm sorry.
So it's not your fault, Mr. Mantsha. It's my fault. So I think we should have it administered now, and I think you can then ask Mr. Mantsha whether the evidence that he has given up to now is true and correct.
Thank you.
Then that should cover it. Okay, let's have that done.
Thank you, Chair.
Please state your full names for the record.
Denel Mantsha.
Do you have any objection to making the prescribed affirmation?
No objection.
Do you affirm that the evidence you will give will be the truth, the whole truth, and nothing but the truth? If so, please raise your right hand and say, I truly affirm.
I truly affirm.
Thank you. If we didn't discover it and somebody else discovered, they would wonder how a judge and so many lawyers, including a lawyer witness, did not remember this. Okay, all right. You may
Thank you,
continue.
Chair. So Mr. Mantsha, you've given evidence on two previous occasions under oath, and you've given evidence again this morning so far. Under the affirmation. Do you confirm that the evidence you gave already this morning is covered by the affirmation that you've just taken, that it was true and correct?
It's true, correct, Chairperson.
Thank you.
Right, thank you. Now, Mr. Mantsha, so there's further correspondence in the file. I don't need to take you through it all, but effectively it says that Ms. Walele says we are not happy that he should just stay at home until the end of his contract, and we demand that you convene the hearing. And then what we have is a response from Denel's attorneys, Cliff Decker, CDH, at page 420.
I'm sorry, Mr. Kennedy. Ms. Walele's letter that you are referring to, what page is it?
I might just have a moment.
Or is that the one we looked at earlier?
Yes, so we've just been looking before the tea adjournment at page 412, which was Mr. Mantsha's own
Yes.
letter. And then there was subsequent correspondence at page 415 and 417 is an example of where she has indicated that they want a hearing, not for the first time in such a request. If I can take you, Chair, to page 418. Paragraph 6, our client holds the view that your client's resistance and failure to follow a fair procedure to determine any wrongdoing is pertinent to the aforesaid, and that an opportunity to be heard by the shareholder of your intention is required. We further believe, since no fair procedure has been followed to date, that there is no grounds for early termination of employment of our client. 7, we therefore urge your client to convene a disciplinary process as a matter of urgency. So are you aware that that letter was sent, or is that just something that happened behind the scenes?
I'm not aware, Chairperson, of the letter.
Okay. All right, thank you. And then we get to the letter I mentioned at page 420 from Cliff Decker, from your attorney, Mr. Adil Patel. And he says, we do not intend, paragraph 1, we do not intend dealing with all the allegations and their reserve rights. And in paragraph 2, your request for a hearing is misplaced. Your client's employment is not terminated due to misconduct. We reiterate what is stated in our client's letter to you dated 17th of March 2016. That was in fact your own letter of 17th of March that we just took you to, Mr. Mantsha. And then he says your client's contract is simply not renewed. Our client does not require your client to work the remaining part of the contract. So that's the answer to the request for a hearing. He's saying it's not needed because your client's employment has now been terminated. It's not going to be renewed from next January. In the meantime, he doesn't have to come to work. Are you aware that that was the position that was taken about?
Absolutely, I'm shocked. I'm not aware.
You're shocked?
Yes.
What later happened, though, was a letter...
I'm sorry. What shocks you, Mr. Mantsha?
No, that this was never brought to us.
Oh, to you, okay.
Then we come to page 422, another letter from Denel's attorneys. And this relates to, I'm going to try and go through this quite quickly now, the correspondence. It, in fact, relates to a further proposal to try and settle the matter, and it refers to what would be paid out to Mr. Saluji. Then if I may take you, please, to, I might have a moment, Chair, page 490. Is yet another letter from Cliff Decker. This time it is dated the 23rd of May, 2016. It's rather faded, the quality of the copy, but it says, it refers to earlier correspondence, and then says in paragraph 2, we confirm that Bafana Ntube of Ntube Incorporated Attorneys has been appointed as a chairperson for the disciplinary inquiry. So it seems at this
what
stage...
What page is that, Mr. Fernandez?
490.
490, okay.
490.
You see that?
Yes, Chairperson.
So it seems that having previously told Ms. Walele, Mr. Saluji's attorney in earlier correspondence, that there is going to be no disciplinary inquiry. There doesn't need to be because his employment is now terminated with effect from the next January, and he's not going to come in the meantime. It appears that was revisited, and now back on course is the proposal or the intention to hold a disciplinary inquiry, and in fact the attorneys have gone so far as to appoint Mr. Ntube, an attorney, to chair the disciplinary inquiry. Were you aware that that was done?
No.
Okay.
But, Chairperson, let me speak under correction.
Yes.
As I said before, that ordinarily this matter, as long as it was still pending, it would served before the board. And as I indicated before, of course the board was not happy with the internal people who were working on the matter. I've explained the reasons and what happened. So the appointment of the chair or whatever in terms as this letter say is not something that is within my knowledge. So as I indicated, we were not dealing with the attorneys ourselves. The respective officials were dealing with the attorneys on the matter.
Right, thank you. Now there's a response to the last letter from Cliff Decker that I've just taken you to, and it's a few pages earlier in the same bundle, page 487. By this stage, it's apparent that Mr. Saluji was no longer represented by Ms. Walele, and he'd moved to Mr. Shahid Dolly. The transcriber's benefit is D-O-L-L-I-E. And Mr. Dolly responded to Mr. Patel's letter, the one we've just looked at, where he said Attorney Ntube would be appointed as the chairperson. And so Mr. Dolly says in paragraph 2, on the 23rd of May, I'm sorry, before I get there, just to note the date of Mr. Shahid Dolly's letter to Mr. Patel. It's the 1st of June 2016. And he says in paragraph 2, on the 23rd of May 2016, you informed us that Attorney Ntube would be the chairperson of the disciplinary proceedings. You further informed us that you would let us know when the disciplinary proceedings would commence, and that you would also furnish us with a bundle of documents your client intended utilizing for purposes of the disciplinary proceedings. The charges have been pending since 22 September 2015. And then he proceeds to explain why his client feels prejudiced because of this delay. And then in paragraph 6, there is a threat that if Mr. Patel doesn't furnish a date when the disciplinary proceedings will actually commence, which must be within a reasonable period, there is an indication that they would bring an application, legal proceedings to set aside his suspension and an order entitling him to return to work and resume duty. Are you aware that that was said on behalf of Mr. Saluji to your attorneys?
Well, I don't recall, Chairperson.
Okay. Can you recall, and I appreciate that we don't have in front of us all the minutes and so forth, but can you from your memory recall at this stage, I also appreciate that at this stage Denel was still in a state of serious difficulties, and your focus on the board was largely on trying to get Denel out of the financial and other difficulties. But can you recall, this is now June 2016, about 9 months since you had taken the decision to suspend Mr. Saluji and the others. Can you recall whether you ever felt concerned that these executives were no longer doing their job because they'd been suspended? They were still receiving pay, substantial pay, and that 9 months or so down the line, they still had not got to the beginning of a disciplinary inquiry, let alone the end of it. Was that not a concern to you? Bearing in mind, for example, you were accusing them of breaches of the PFMA, but under the PFMA, you, as executive authority, had the obligation to ensure that discipline was taken and to avoid fruitless and wasteful expenditure.
Just correction, Chairperson, the board is not an executive authority in terms of the PFMA. The board is an accounting.
I beg your pardon, you're quite right.
It's an accounting authority.
But you still had that obligation, not so.
Well, let me say, Chairperson, we were extremely concerned about the delays in this matter. And as I alluded before, there was people internally, as I've identified, the former acting company secretary, who was at the same time the head of legal. So there was, in the opinion of the board at the time, a deliberate strategy to frustrate the process, to move it slow. And of course, we were concerned and we tried to push that person out. I cannot tell you when the person was pushed out, but we were concerned about it. It was a big concern because we wanted closure on the matter.
Thank you.
I just want to go back to what you and I had an exchange on with regard to the delay. Of course, is it not true that if a disciplinary inquiry was held, there would be the possibility that the executives, or Mr. Saluji, the executives, could be found not guilty. And if they were found not guilty, the board would have no option but to allow them back into their jobs. Would you accept that proposition?
No, there was no possibility of them not being found guilty. It was not possible.
Well, I'm not sure why you say that if you were not going to chair
if you are not going to
chair the inquiry. I mean,
Look, Chairperson, I can tell you why I'm saying this.
Yeah.
Because you see, firstly, when you take a decision
Yeah.
to suspend, I think as the evidence showed here, it was not like one morning people wake up and go and suspend. There were several meetings, there were investigations. Members of the audit committee, some of them were delegated to meet the bankers, Nedbank and ABSA, try to find out what really happened. And they got a side of the story from Nedbank, because Nedbank were helping from the transaction. So there was an investigation which was conducted on the matter. And, Chairperson, you act on the basis of the approval that you are given by the two executive authorities, which is Minister of Finance and Minister of Public Enterprise. And on the documents, you were given an approval of 5 years to pay the loan. And you go and change that to 6 months or 5 months to pay that loan. Clearly, on the face of the document, you have contravened the approval. There was no approval for 6 months. So which means, in effect, that transaction was not approved. And this is the evidence that it's conveniently now serving before this commission. There was no proper approval for that transaction. Because when the terms, so Chairperson, when you enter transactions like this, I know you know this very well in your previous life, you prepare a term sheet where the term sheet records the agreement between the lender, in this instance, these two banks, and Denel. And that term sheet is submitted for the purposes of the PFMA approval to the relevant executive authority. In this instance, is Minister of Finance and Minister of Public Enterprise.
Can I stop you there?
Yes.
I think, let's put it this way. I think your answer to my question is the evidence against the executives was so strong that you are saying there was no chance of them being found not guilty.
Correct, Chairperson.
Yes. Of course, that strengthens the difficulty about delaying when you are so certain that, these people, there is no chance of them not being found guilty. But we have dealt with that. I'm not wanting us to go back. Back there.
Just to add on that, Chairperson, precisely the delay was not on the part of the board.
Yeah.
The board acts through functionaries, being HR, being company secretary, being the head of legal. They've appointed reputable law firm. So it was not on the part of the board.
Well, you see, for me, or let me ask this question, are there any specific steps that the board took against people in the management who, according to the board, were failing to do their job properly because their job was to make sure that this process was expedited?
Yes, we did, Chairperson. The acting company secretary at the time and the head of legal, we took steps. We had to remove that person.
Yes.
And as I said earlier, there was also clear evidence of leaking communication between herself and the board to this executive. And it was clear to us that she's deliberately aiding them, maybe because they were working together for a long time, they developed some allegiance to one another, but she was deliberately aiding them, and we took action.
And when was that, if you are able to remember?
I think, as I said, Chairperson, I mean, when this matter, as a standing matter to the board, comes to the board, So the minutes would have captured
Yeah.
a lot of our displeasure and a lot of our discussion about this matter.
But have you got a recollection whether it might have been 2015 or 2016, or you don't remember?
No, I don't think it's. I'm not really sure.
Yeah.
But I'm not really sure.
Yes.
But
Okay.
I don't think it's 2015.
Yeah. You say you removed the head of legal.
The company secretary eventually, I think I'm speaking under correction because there were a lot of pressure we put to the acting CE and the acting CFO because the two of them were also getting pressure from the lenders to say,
What's happening?
yeah, what is your standing talking to us because you are acting?
But I
And
wanted
think
just
they put-
to.
I think
to-
they put a lot of, sorry, Chairperson, sorry.
Yeah, I just wanted to have the names of the people you say you took action against. Was it the company secretary and the head of legal, or was it the company secretary only? I wanted the names of the people or their positions against whom you took action because you believed as the board that they were delaying or failing to expedite the process. You said it was the acting company secretary, is that right?
Yes.
Was
And
there
the head of
somebody
legal
else?
Well, she was the only one who was solely responsible with the matter.
Yes.
Yes. So that is the only person that
The head
action
of
was
legal.
taken. Yeah.
What was her name? Do you remember?
It was the Likabe Ocho.
Miss Lechabe.
Yeah.
Okay. Mr. Kennedy?
Thank you, Chair. So after this correspondence between the attorneys, Mr. Mantsha, we know that from the documents, I don't know if you recall or have knowledge of it, Mr. Saluji then lodged a dispute with the CCMA. Are you aware of that?
I see the referral form here.
Yes. Not sure why we've got to hold back. In fact, the referral is right here, as you point out. It's from page 492. We don't need to go into the content of that. That was referred, and the dispute was then resolved. Are you aware then that there was a settlement with Mr. Saluji?
Well, eventually there was a settlement with
Yes.
Mr. Saluji, which was, I think, facilitated by the former CFO.
Yes. If I can just have a moment. Yes, it's page 513. In fact, it starts a bit earlier. Sorry, Chair.
Is 5.3, is that a paragraph of a document?
I'm sorry, I just need to
Oh,
check.
okay.
I thought it was 513. It actually starts at page 499.
Okay.
Now, I think we touched on this on the previous occasion, but there are just a few aspects I need to ask you some questions on. Were you a signatory on behalf of Denel to that settlement agreement? If I can take you to page 513, it seems that it was signed not by you, but someone else. Mr. I can't actually quite read the writing of his name. He was acting group financial director. Can you help me with the name? Is it Mr. Mshlowana?
Yeah, I see here is the former CFO of Denel, Mr. Mtlwana.
Yes, he was acting at that stage. And we see that that settlement agreement was signed on the 8th of November 2016. So that was some 14 months or so after they had been suspended, correct?
Correct.
And just a couple of points I need to raise with you here. The terms of the settlement reflect that he was given an ex gratia payment on the basis that his employment was terminated, and the ex gratia payment was the amount of 2,362,492 rand. Were you aware that there was the settlement? You'll find that at page 505, clause 6. Presumably this must have come to you or your board for approval to settle with Mr. Saluki?
Well, it was debated in the board.
Yeah. And did you give your approval? You didn't.
The
you
board
didn't resist.
approved it. The
Right.
board approved.
And so that, as it says, the 2.36 odd million rand is an amount equivalent to 50% of the of his annual remuneration. So he got effectively a payout of 6 months' salary, an amount equivalent to 6 months' salary. Were you aware of that?
Well, yes.
Okay. And that was, in addition, there were certain other amounts such as accrued leave in clause 5 and so forth. Now, this was in addition to the payment that had already been made pursuant to your letter earlier that year, where you had said, we've decided not to renew your contract, but we'll pay the rest of the year out. And that was duly paid, long before he referred the dispute to the CCMA.
I don't remember that payment, Chairperson.
Okay. So on the basis of his, and that we know was about 10 months from the time of your letter, and that was in addition to the 7 months that he'd been suspended. So if we take all of these periods together, he was on paid suspension for 7 months until you terminated his contract by saying, we're not going to renew it and we are not requiring you, we don't want you back. Then there was another 10 months to the end of the period of contract, so that was 17 months, and in addition, Denel, were now paying him out ex gratia another 6 months of salary to resolve the dispute. Correct?
Well, Chairperson, just to give some background.
Yes, I'm just asking you for the facts, and then I'll ask you for the background.
No, but you made a statement that I don't know where you're getting the facts from.
So is it a request for clarification?
The letter which indicated, as was read, that we're terminating your contract. I don't remember that there was payment after that. So
after when?
there's a letter which he has read.
The one about 10 months payment.
The one about, it proposed termination and all sorts of things. I don't remember there was payment made at that stage. I remember there was payment made at the end of this settlement.
Yes.
Yeah. But again, I mean, I would rely on the figures which are set on the document.
Now, the letter which, the payment that you say you don't know whether it was made, that would be the payment in terms of the letter which I'm under the impression you signed of 17 March.
Yes.
That's the one. That letter did say to him he was going to be paid for the rest of his balance of his contract period.
Yes.
But that it said that you know, but what you say you don't know is whether that was implemented.
Indeed, Chairperson.
Yeah. Okay.
I haven't seen any evidence to show that that was accepted and implemented.
Yes. Okay.
That's fair enough, Mr. Mantsha. Thank you. And I rather skipped over a few letters in the hope that we could make some progress, but I'm happy to take you back to page 422.
Page?
422. Uh, 422 is another letter from Cliff Decker, CDH, dated the 13th of April 2016. That was shortly after the letter that the chairperson has just referred you to, that you confirmed that you signed. And he says, we record that in relation to this dispute, your client's employment has been terminated, and your client, and that is Mr. Saluji, has been paid out for the remainder of the term of the fixed-term contract of employment up to and including 31 January 2017. So that was what Denel's attorneys confirmed. Mr. Saluji's attorneys then wrote back and said, yes, we confirm we've received it, but we don't accept that that's sufficient. We want a disciplinary inquiry. We're not satisfied that you are entitled to terminate. And Mr. Saluji's also given evidence that he did receive that payment.
Yes, that's what I wanted to confirm also, that in his oral evidence, he confirmed that the money was paid into his account.
Yes. Thank you, Chair. So I appreciate your position, Mr. Mantsha. You don't know, you can't remember.
I don't know.
But I just thought, in fairness, I need to show you the missing evidence as you
Thank you, Mr.
suggested.
Kennedy.
Thank
But
you.
let me ask you about the payment that you know about at the end. You said the board debated the matter and approved the final settlement. Why did the board in November 2016 give Mr. Saluji, who had not been working, who had not rendered any services to Denel for over a year, why did it decide it should give him any money other than what was due to him because his contract was going to expire in January?
Chairperson, as I indicated earlier, there was a long discussion which in this instance was the company was represented by the then CFO. By the then CFO, talking
Yes.
directly to
Yeah.
the suspended employee.
Mr. Nchepe, that was
Yes,
Mr. Nchepe.
and at that stage we were under tremendous pressure. We were under tremendous pressure to stabilize the company. Stabilize the company by having permanent appointments in order to give assurance to our lenders, to our business partners, that whatever decisions we arrived at, whatever negotiations we are busy with, these officials are permanently employed and they will be there to see this decision through. So the settlement was driven primarily weighing the interest of the company at the time, what the company was losing at the time because of the vacuum at the top. And of course, there was submission by the relevant officials to the board to say, look, this is where we find ourselves. And in view of all these problems that we have in terms of stabilizing the company, stabilizing the business of the company, we have the view that this kind of settlement would be in the best interest of the company. And after the board has considered the issue and considering the pressure at the time, the board was of the view that it was in the interest of the company that this matter must be closed so that we can then move on to have permanent appointments, which would then give confidence to our partners, give confidence to our lenders. So it was just the interest of the company that has driven us to accept the submissions made. Firstly, of course, there were submissions made by the executive to say, look, can we talk to these people? If I remember, I think the CFO was approached. I'm not sure whether by the suspended CFO at the time. And they started to explore these issues. And of course, he came to the board to say, look, this is what we think is in the best interest of the company. Can we proceed to talk? He was given a go-ahead to talk. And when he has reached this kind of conclusion, he came back to the board and said, look, we request that you approve this for these reasons. And the board took the decision.
Well, I must just say, Mr. Mantsha, it doesn't make sense to me.
Well, Chairperson, it's not going to, sorry to
Yes.
interrupt, it's not going to make sense to you
Yes.
because you have no benefit of the discussions of the board. the rationale of arriving at this is not before you. So I don't accept this to make sense to you. And as much as you shouldn't expect me to then reprint what was discussed when these discussions was taking place, because I don't have it in my head. But there is a context, there is full discussion about this. And again, Chairperson, I'm talking to somebody who has presided over settlements many years of your time, and Mr. Kennedy as well. We sit here as the Commission, looking back to 5 years ago. As the Commission, as we sit here today, we do not have the submissions made to motivate certain decisions. And if we then expect the Chairperson of the Commission to come to more or less same conclusion with those who were given the submission, or expect the Chairperson of the Commission to say, this is reasonable, this is not unreasonable. In the absence of those submissions, I think it is a difficult. And it is difficult for me as I represent the board to then go point by point on those submissions I do not have, and try to explain submission by submissions and the reasons by reasons. So I think it is unfair to expect that kind of thing. I think the nature of this process, Chairperson, we must accept that certain things we might not understand properly because we were not there 5 years ago. We were not seized with the moment, because apart from, if you look at the settlement, this settlement is not in isolation of the total issues that the company was facing at the time.
Yes.
So those who took the decision, they had to look at the bigger picture and satisfy their fiduciary duty to say, look, we can pay this amount, but for the greater good.
Yes, you see, I wanted to say, in particular, what makes this not make sense to me is that in March, Denel is aware that Mr. Saluji's contract is going to come to an end by a fraction of time in January 2017. It is even aware that that would not be seen as a dismissal. It would just be the coming to an end of a fixed-term contract. It has taken the decision it won't renew it. Various things happen in the meantime after that. Now in November, Mr. Saluji is left with November, December, January for his contract to end. He has been on suspension for more than a year. All that one would expect is that at that stage, Denel would simply allow the contract to come to an end by the fraction of time. If Denel wanted to appoint a permanent CEO in order to address the concerns of investors or whatever, if it made an announcement that appointed a CEO, but he would start with effect from beginning of February after the expiry of this contract, at least the investors would know that at least now there is going to be a permanent CEO. So you have a situation where, as far as Denel is concerned, as far as the board is concerned, for over a year, it is sitting with, on its version, very strong evidence that these executives are guilty of serious misconduct. No hearing takes place. closer to the end of the contract period, 3 months, if they just allowed the contract to expire, they would not pay anything extra. They pay him more. I don't know whether it's 3 months more or 6 months
It
more.
was 6 months more. Chair.
Yeah, they pay him more. This person that they say has put the financial position of the company in a very difficult position. They give him some more money that he's not entitled to. So, but I don't want us to go back, but I just want you to understand what's going on in my mind.
I really
Yes.
appreciate that, Chairperson.
Yes.
Let me just say one thing. What are we settling? What are we settling? We are settling a litigation.
What?
We are settling a case. We are settling a litigation. And Chairperson, you would know that whether I have got a case or not, it's a matter for another day. At this stage, we consider to be in the best interest of the company that the litigation must be closed. And this is the primary reason of the settlement for the reasons that I have given. Because whether the contract is finishing in 3 months, whatever the case, there was dispute in every point. And we did not want to sit in that dispute because it was harming us for the greater good. That's how far I can leave it.
Okay, all right. Mr. Kennedy.
Thank you, Chair. Just to complete the factual situation as to settlement, we've dealt with Mr. Saluji's settlement in relation to how much he was paid, and you've explained why. On the same page, 505, clause 4.2, says it is recorded that all disciplinary proceedings against the employee have been terminated. Were you aware that one of the objectives and terms of the settlement agreement was to abort the disciplinary inquiry that was still to take place?
It was to terminate all the legal action.
Yes. Well, I'm referring not to legal action in general, I'm referring specifically to disciplinary proceedings.
Yes.
Yes. Now,
And just to confirm also, there was no litigation at that stage between the executives and Denel, is that right?
Well, there's a letter where there was a threat for some applications and all of that.
may I just help you, Mr. Mantsha? I'm sorry to cut you short, but it seems to me that
Nothing came of it.
that there was litigation in this sense, apart from that threat of an urgent application, which presumably they were threatening to bring in the Labour Court, although they didn't say it. There was litigation in the looser sense, in the sense that he'd already referred his dispute to the CCMA. So it was a legal dispute that was pending before the CCMA,
Okay.
and we saw the referral that you in fact pointed out. There was a referral document there. So in that sense, there was litigation.
Okay.
I'm sorry to have
No, that's
preempted
helpful.
the witness to have answered your question.
No,
but-
that's helpful, yeah.
But that seems to me, Mr. Mantsha, to have been present in your mind with the board, that you want to terminate any disputes. So there's a dispute about whether they were guilty and so forth, which could have been the subject of a disciplinary inquiry. He was raising disputes, threats of urgent applications, which he doesn't seem to have carried out. But what he did carry out was the threat to bring a CCMA dispute before the CCMA, and that was then pending. So this was all completely resolved, including the disciplinary proceeding.
Correct.
Right, thank you. Thank you, Chair. I'm sorry if I
No, that's
stepped on
helpful.
his
No,
toes,
that's
but
helpful.
I thought I could assist. Mr. Mantsha, we've touched previously in an earlier session before today on the fact that there was
I'm sorry, Mr. Kennedy. I just realized that for some reason I don't have the second page of the letter at 422.
I'm sorry, 522.
422.
422.
One page only. But your junior could attend to it while you
I see we have the same problem.
or,
We have the same problem.
if that can be addressed,
Yes, perhaps, with your leave, may we
during
locate
lunch.
that page and have it inserted.
Yeah, that's
Thank
fine.
you, Chair. Apart from Mr. Saluji, Mr. Mantsha, you also, of course, had two other employees then on suspension, Mr. Mshlontlo and Miss Africa. And the evidence from Mr. Mshlontlo has been that he signed a settlement agreement and he was paid an ex gratia 6.6 million rand, which was equivalent to 24 months of his salary, plus a bonus of 1.6 million rand. Did you also have that brought to the board's attention for your consideration and approval?
Correct.
And he, of course, had not litigated, although the attorneys were acting on his behalf, expressing concern that there were delays with the disciplinary inquiry, etc.
Correct.
So all of that issue was settled with Mr. Mshlontlo to the tune of 6.6 million rand plus the bonus. And then we also know that Miss Africa also had a settlement concluded with her. Were you made aware of that at board level as well? There was a settlement on the basis that Denel and she agreed that she would then take early retirement, and then apart from whatever benefit she may have had under a retirement or pension fund, she was paid a settlement amount of 1.6 million rand, equivalent to 12 months remuneration in her case, plus accrued leave, plus 75% of an incentive bonus. Were you aware of that settlement?
Yeah.
On those terms?
Approved by the board.
Yes. I'm not going to take you to those settlement agreements. You appear comfortable with the point that I'm putting to you. So there were very substantial amounts that were paid to these various executives. Mr. Mshlontlo appears to have got perhaps the most, but bearing in mind his senior position and also the fact he was a permanent employee, whereas Mr. Saluji was not. He was on a fixed-term contract. So it was 6.6 million plus another 1-point-something million for Mr. Mshlontlo. We know it was about 2.4 million in the case of Mr. Saluji, in addition to what he'd already been paid for about 17 months. And then Miss Africa was 1.6 million, in addition to accrued leave, etc. In relation to those two other executives with whom there were settlement agreements, is the reason why, the justification why the board approved those settlements, is the justification effectively the same as the justification you've already given in relation to Mr. Saluji's settlement? Or were there any different factors?
Well, Chairperson, as I said, there were proper presentations to motivate the settlement of the two executives.
I'm sorry, just start afresh, yeah?
Thank you.
Well, to start with, I did not give the detail of the motivation here. I just highlighted certain points which were primary drivers to those settlements. But I'm saying there are documents which have been submitted to motivate those settlements. And of course, those documents would have given reasons for both Mr. Saluji and both Mr. Mshlontlo on those amounts that were finally agreed, and the submission would have given reasons why Miss Africa, there must be settlement the way it was. Yes, it would contain all those reasons. I might not say all of them here.
Oh, of course, I accept that. I accept that. Now, may I just go, and I want to be very brief on this because it's been traversed in some detail already, particularly in questioning from the learned chairperson. I just want to give you a final opportunity to reflect on this question and give an answer. If we accept your logic, if we accept your facts and your logic, then there were very serious charges against all three of these individuals. You suspended them, you say for good reason that you've explained. You had them charged for good reason that you've explained. You had an unanswerable case, as you've explained. They could have been fired on the spot, was your evidence a few weeks back. And if you had done that, you could have terminated their employment. You're very confident about that result. And you would have then not needed to settle anything. The settlement appears to have been of the order of almost 10 million rand. We're talking here not of Mr. Mantsha's personal money, but of Denel, which was a public corporation, a state-owned entity, having public funds that are now being spent in terms of settlement agreements, and public funds held by a state corporation that was in dire straits, as you and many other witnesses have given. I just want to give you a last opportunity to try to explain what I perceive as a logical problem. Because if we accept all of your logic at the beginning, you had a perfect case, you had great evidence, you had the law on your side, you suspended them for good reason, you were disciplining them for good reason, and you could have done it, and it wasn't done. Instead, you paid them out settlement amounts that you didn't even need to pay. In Mr. Saluji's case, you said, we want to fire you now, and you didn't discipline him. You then said, through Mr. Patel, the attorney, you said, we don't have to employ you past January next year, so we don't need to discipline you in the meantime, so we paid you out until the end of that. Mr. Saluji then could have been left on the basis your contract has come to an end. Instead, he's paid another 6 months. And so I can go on with Mr. Mshlontlo and Ms. Africa. Do you understand the logical difficulty that I have? And I would invite you to explain. If you could have done it, and you should have done it at the beginning, why didn't you, when it actually meant that you were paying approximately 10 million rand in that sort of ballpark of public funds that Denel desperately needed?
Okay, let me deal with what you term your logical difficulties. I'm called here as a witness in my capacity as a chairperson, the then chairperson of Denel. There are issues raised about decisions of Denel. I mean the decisions of the board. But there's no attempt to bring the documents upon which those decisions are made. You are given the information as you are given today. You have listened to my evidence, and you have listened to the evidence of many of Denel witnesses. And some of them, Mr. Kennedy, you cross-examine them, you question them, to give you the information, the past and the current. But clearly, the evidence that they have told you, objective evidence that they have told you,
Yes.
you should not have that difficulty that you're raising to me.
Why is that?
For simple reason, because your difficulty is based on confusing the substantive nature of the process and the steps which were taken to prosecute the substantive part of it.
How am I confusing them?
I have already told the chairperson that we did in fact act as the board. We were not impressed with the delay.
Yes.
We changed the person who was responsible. I even told you that the letter that you have read to me the last time was in fact leaked to the suspended employee, which to us as a board signal that this person is deliberately frustrating this process, not to move. Not to move. So, when you say having such a strong case, which we could have dismissed them, and eventually that did not happen, there would have been saving if that process would have been taken forward. But what you also don't say, it's how far the litigation would have gone and at what cost to the company in terms of the money we pay to the lawyers. And I think you would appreciate that the law firm that we were using is one of the biggest law firms in the country.
Undoubtedly.
So it doesn't come cheap. So there's a cost here to the lawyers. There's a cost to whatever we were going to pay. We did not know, as you know, you know it better than me, that this litigation can drag a very long time. So there would have been money to be paid there. But there's also opportunity cost that is difficult to quantify, that we wanted to have stability.
Yeah.
We wanted to assure the investors, the lenders, that yes, there is permanent leadership. When you talk to them, the decision that you make with them, they have got 5 years to see them through. We were trying at that time to renegotiate the Nedbank law. And it was difficult. I remember I've attended, there was a high-level meeting which was called at ABSA, where they requested me as a chairperson. And they've raised the issue of stability at the top. And I think there was another meeting where Nedbank representative involved in the matter came to the company, and they've raised these issues. So the opportunity cost and the cost to litigation and other related costs, whether you were going to do a disciplinary hearing, there were costs involved, as I've outlined.
Even 10 million costs.
It could have been more. I mean, you know, in this profession, depending on who you employ, some would charge you a lot of money per day. So we don't know.
Do you believe that you had an unanswerable defense to those cases?
Yes. The case is a strong case, not only by my evidence, but by objective evidence that you were told in this commission. That in fact, we are taking steps to try to recover the money. So that evidence you were told. So that is the objective evidence. So it does not mean the fact that there was a settlement, it was waste of money. What I'm saying to you, you were not in the position of the board, you were not in the positions of those executives. Those executives and the board had to take a decision given the material condition at the time. And that decision was taken informed by a lot of dynamics. Considering the cost of 10 million that you're reading to me, we could have litigated more than 10 million. The opportunity cost more than 10 million and other related consideration which the board has considered. I don't expect you, with the limited information that you have, and not having the sight of deliberation and submissions which were given to the board to motivate settlement on those amounts, to find it reasonable. It's difficult for you to get there.
Yes,
because even the evidence that you are going through here omit the evidence which was presented to the board.
No, but that's why I'm debating it with you. You know, you say you're not surprised I can't understand.
Yes.
I'm simply saying to you, I'm not putting what I would want written in a report or a judgment or anything. I'm simply saying there seems to be a logical disjuncture. If there isn't, please tell us why.
Well, in
why
the
there
absence,
isn't.
in the absence of these documents that I'm telling you, of course you wouldn't understand. It's logical. But if you were to take me through, this is what was presented to the board as far as the rationality of this settlement and this and this and this to you does not make sense. It's one thing to stand here today and go back 5 years and try to decide that no, that was wrong. And we were never in the shoes of those people who were making decisions at the time. And that was the time of a serious political turmoil in this country.
Right.
There were a lot of things happening in this country. We were preoccupied to save the company. We were preoccupied to satisfy the lenders and the investor, to say we are stable. You can deal with us. The agreements we make with you will be honored because this executive have got 5 years to stay.
All right, thank you, Mr. Mantsha. Chair, I'm going to move away from that whole topic and move to another one.
Yes.
I'm happy to start. Time
think
is
you may
precious,
start.
particularly in this commission.
Yeah.
You want me to start?
I think you may start because we still have about 12 minutes or so.
Thank you very much. I'm
Yeah.
absolutely happy to go
Yes.
however long you want as well.
Yes, okay.
All right. I want now, Mr. Mantsha, to get to the issue of benefits you may possibly have received from the Gupta family and their business associates. Now, let me just understand if I got your evidence previously. As I understood your evidence in an earlier session with us some weeks ago, you indicated that you sometimes travelled overseas during this period that the Commission is looking at. And sometimes you would travel on official business for Denel, in which case your travelling costs would be paid for by Denel, and we have no difficulty with that. But you also indicated that there were some trips that you would take that weren't for official business of Denel, and that you always paid for that yourself personally. Remember, you gave that evidence.
Indeed, Chairperson.
I'm doing justice to in my summary to your evidence.
Indeed, Chairperson.
And does that mean that whenever you travelled other than for official Denel business, which Denel would have paid for, whenever you went overseas for other reasons, let's call them personal reasons, you would pay for the air travel and the accommodation and related expenses?
Correct, Chairperson.
Right. Now, there are some documents in the bundle. Chair, may I take you, Chair, and the witness to the bundle specific to Mr. Mantsha? It's bundle 8, and it's exhibit W22.
Going to go back to this other bundle, or can they take it away?
No, they can take it away for the time being. I don't
Yeah.
think we're going to come back to it later, but perhaps if it's just kept somewhere
Okay.
fairly close.
You said bundle?
Sorry, it's bundle 8. It should have on the spine Denel bundle 08.
I've got W4, A.
I'm sorry, Mr. Mantsha, I didn't hear you. If you have that file, you'll find exhibit W22 starts at page 319. And if I can remind you, just look at the top left-hand corner for those page numbers. It's exhibit W22, Mr. Mantsha. Just
Will your junior assist him to find the file?
yes, perhaps we should. Can someone approach the witness?
Yeah.
Okay,
Junior?
I see 22 this one.
Have you got it?
Yeah.
Thank you. And if I can take you, just to make sure we're talking in the same bundle, if you look at the top left-hand corner of each page for the page numbers, go to page 330. That was your first statement that we went through on the previous occasion.
What's the page number?
330, Chair.
330, okay.
330.
Yes. In your version, is that the first page of a statement that you signed?
Maybe you,
Do you not have...
Registrar can help me.
Perhaps may my learned junior approach the witness and
Yes, sure.
assist to
Yeah.
ensure.
Yeah.
Thank you. Yeah. Thank you. I'm told by Melinda Jr. that Mr. Mantsha has indicated privately to her that he would like a comfort break.
Oh, yeah. Then maybe we may as well take the lunch break.
As you please, Chair.
Yes. So let's take the lunch break and we'll resume at 2 o'clock.
2 o'clock. Thank
We
you, Chair.
adjourn.